All right, guys. A federal judge in California just overturned the state's 32-year ban on assault weapons, assault rifles as they were, as unconstitutional. He did it in a 94-page opinion. It is scathing. It is beautiful. I only wish I could go through all of it line by line in one video without boring everyone to death, because this guy has laid out a wonderful case. So let's talk about what's going on. We're going to take a peek at two short segments of the document, and we're going to take a look at a news article as well, because California is seething. They are seething about this decision, but the judge has laid out how constitutionally this is the appropriate course. And I actually 100% agree that he is right on the money here. This ban is unconstitutional. It has been unconstitutional. It infringes upon the Second Amendment, and he calls out the nonsense pretty plainly in his opinion at multiple points. So let's get into this. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, make sure you go ahead and hit that like button, hit subscribe, and turn on your notifications so you don't miss any videos. All right. First thing we're going to do is we're going to take a look at this article. And you can see I picked this one from Reuters. It's the same everywhere. They've lost their minds. They don't know what to do because this judge has just shown that this ban is not constitutional, and he did it in an extremely thorough way. And we're going to talk about how important it was for this judge to issue the ruling in the way he did. That is a key component going forward. So, on the question, Let me get this out there right now. Can I buy an assault weapon or an AR-15? Because an AR-15 isn't an assault weapon, but it is under the California law definitions because it looks scary. Can you buy one in California right now? No. Will I be able to buy one in a month and a half? Probably not. But we'll see how this goes with the California Court of Appeals and all of that stuff. So here we go, or the Ninth Circuit Court of Appeals. And I'll tell you what I think is going to happen as we go through the video. So a U.S. federal judge overturned California's 32-year-old ban on assault weapons on Friday, describing it as a failed experiment and prompting scathing criticism from the state's governor and attorney general. Who cares? Those people are idiots. Gavin Newsom, why does anybody listen to him at all? After 2020, why does anybody listen to this man who is a hypocritical tyrant? California has prohibited the sale of assault weapons since 1989. The ban was challenged in a 2019 lawsuit against California's Attorney General by plaintiffs including James Miller, a state resident, and the San Diego County Gun Owners, a political action committee. This case is about what should be a muscular constitutional right, and whether a state can force a gun policy choice that impinges on a right with a 30-year-old failed experiment, says Judge Roger Benitez of the United States District Court for the Southern District of California in his opinion filed late on Friday. Quote, government is not free to impose its own new policy choices on American citizens where constitutional rights are concerned. It is declared that these statutes unconstitutionally infringe on the Second Amendment rights of California citizens. The court filing concluded the Second Amendment of the United States Constitution guarantees citizens the right to bear arms. Of course it does. We all know this. The only people who this is a surprise for is the media and California politicians. That's it. So the state attorney general says that the decision is fundamentally flawed and they'll be appealing it. Here's what's going to happen. They're going to appeal it to the Ninth Circuit Court of Appeals. They're going to get a 3-panel judge. Now, Trump appointed a bunch of judges to the Ninth Circuit, and they actually have been making some conservative-minded decisions as of late. However, what will likely happen is it will either get overturned at the Ninth Circuit, and then hopefully this will go to the Supreme Court, or it'll get upheld at the Ninth Circuit, and then it'll be moved to have a rehearing en banc, and the Ninth Circuit court as a whole, or it's not actually as a whole, but the en banc court will come in to rescue the gun ban. That is the likely outcome. That is what they have done on all of the other pro-Second Amendment decisions that have come out of California when a Bush or Trump-appointed judge actually makes the correct decision. When they actually make the correct decision on a Second Amendment case, and it gets past the initial Court of Appeals, there's an en banc ruling. That means that it's a group of 15 judges. It's supposed to be every judge on the appeals court, but in the Ninth Circuit, there's so many of them that they just get a group of 15 judges to come in, and then they rehear the case, and they vote. And in the en banc rulings, they have overturned all of the pro-Second Amendment decisions. So we'll have to see how it goes, but that is my prediction of what will happen, and then it will be up to the Supreme Court. And this is why the judge's 94-page, extremely thorough, meticulous decision is important. Because this decision needs to be cited every step of the way. It needs to be cited at the appeals court heavily. He's done a lot of lifting for the next round of litigation, and then it needs to be cited over and over again at the Supreme Court level, because this is the correct approach to these things. Now, let's take a look at two of those sections, and I'll show you what I mean. We're going to read the introduction, which is a couple paragraphs, and we're going to read the Heller test, which is referring to DC versus Heller, which is the landmark Second Amendment case from 2008 penned by Justice Scalia. And he is going to use the Heller test to show how this is plainly unconstitutional under law that has been in effect since 2008. Technically since before, but actually put down on paper by Scalia in his 2008 decision. I don't like just reading documents, but this is such good stuff coming from a federal judge in one of the most abusive to the Second Amendment states in the nation. And in certainly the most abusive circuit to the Second Amendment. This judge just lays it down. So we got to go with his words because it's great. It's great. So here's the introduction. Like the Swiss Army knife. Oh, and that line, by the way, that line has the media pissed off. Well, he compared it to a Swiss Army knife. Yep. He means it's multi-purpose, multi-use, very, very versatile, and also very, very popular. Like the Swiss Army knife, the popular AR-15 rifle is a perfect combination of home defense weapon and homeland defense equipment. Good for both home and battle. The AR-15 is the kind of versatile gun that lies at the intersection of the kind of firearms protected under District of Columbia versus Heller and United States versus Miller. So he's even going back to U.S. v. Miller. That's the 1939 ruling that basically allows all of the gun regulations that we have. So he's saying this falls within the regulatory scope of Miller, and these are still protected guns. Yet the state of California makes it a crime to have an AR-15 type rifle. Therefore, this court declares the California statutes to be unconstitutional. Plaintiffs challenge a net of interlocking statutes which impose strict criminal restrictions on firearms that fall under California's complex definition of the ignominious assault weapon. Hearings on a preliminary injunction were consolidated with a trial on the merits pursuant to Federal Rule of Civil Procedure 65A2. So this case was brought in 2019. And they moved to have a preliminary injunction to stop the assault weapons ban back when they started. But instead, they merged the preliminary injunction with a trial on the merits. They said, we're going to just take this whole thing to the one hearing. No use having two separate hearings on it. And they're going to have one hearing on it and rule on the thing. So this is not just a preliminary injunction. It is also the final judgment on this case. Having considered the evidence, the court issues these findings of facts and conclusions of law, finds for the plaintiffs, and enters judgment accordingly. Here we go. The Second Amendment elevates above all other interests the right of law-abiding, responsible citizens to use arms in defense of hearth and home. The Supreme Court clearly holds that the Second Amendment protects guns commonly owned by law-abiding citizens for lawful purposes. At the same time, the Second Amendment confers an individual right to keep and bear arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. And although the Supreme Court cautioned that the Second Amendment does not guarantee the right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose, that's the words of Scalia, lower courts have often cited this proviso about extreme cases to justify gun laws in average contexts. He's setting up the dichotomy here. Scalia is talking about edge cases. He doesn't want a guy walking around with a vest full of hand grenades, for example, throwing them around in a public park. That's not a lawful purpose. That might be outside the scope of the Second Amendment. Or maybe some sort of very, very high-tech automatic shotgun, right? Like this is not a common use item, and its purpose is geared more towards military uses. I disagree with that. Personally, I want an automatic shotgun. I think that would be a lot of fun. But that being said, these are the type of outside cases that Scalia is talking about, but the states have used that exception to make the exception the rule. The states who have banned these assault weapons and stuff like that. All right. There is no evidence that the Supreme Court intended that language to be a license to avoid its common sense holding in average contexts. Unfortunately, Heller's acknowledgement of exceptions for gun laws at the extreme is in danger of swallowing Heller's rule for the average case. This case is not about extraordinary weapons lying at the outer limits of Second Amendment protection. The banned assault weapons are not bazookas, howitzers, or machine guns. Those arms are dangerous and solely useful for military purposes. Again, I disagree, but we are talking about a California judge still. Instead, the firearms deemed assault weapons are fairly ordinary, popular modern rifles. This is an average case about average guns used in average ways for average purposes. This is not the edge case. This is not the exception. The AR-15 is the rule. It's the most popular rifle on the market, that style. It's owned at extremely high rates. Well, I'll let him talk about it. One is to be forgiven if one is persuaded by news media and others that the nation is awash with murderous AR-15 assault rifles. The facts, however, do not support this hyperbole, and facts matter. Ooh, it's good. Federal Bureau of Investigation murder statistics do not track assault rifles, but they do show that killing by knife attack is far more common than murder by any kind of rifle. In California, murder by knife occurs 7 times more often than murder by rifle. For example, according to FBI statistics for 2019, California saw 252 people murdered with a knife, while 34 were killed with some type of rifle and not necessarily an AR-15. A Californian is 3 times more likely to be murdered by an attacker's bare hands, fists, or feet than by his rifle. In 2018, the statistics were even more lopsided, as California only saw 24 murders by some type of rifle. The same pattern can be observed across the nation. And he's right. If you go through, you'll find that rifle-involved deaths are much, much lower than several other categories, including knife, bare hands, feet, fists. I think even hammers might outdo rifles. So despite what's going on lately with the media has been pushing this narrative that these rifles are murdering people left and right in mass shootings. We get reports of mass shootings by the truckload now that Joe Biden is the president and the Democrats are in control of Congress, because they're trying to push the narrative for gun control. That is the point. That's the purpose. That's what they're doing. It is intentional. It is all intentional to have this narrative that these things need to be brought under control, when in fact, they're not the problem. But they look scary. All right, so now we're going to look at this one last section. It is the Heller test, and it is all encompassed on the page that I have right here. So he went through a fact section. Now he's going to apply the Heller test from Scalia's ruling. With these principles firmly established, it is time to put the constitutionality of the AWCA to the test. Two tests will be used, the Heller test and the Ninth Circuit's two-step level of scrutiny test. The Heller test is a test that any citizen can understand. Heller asks whether a law bans a firearm that is commonly owned by law-abiding citizens for lawful purposes. It is a hardware test. Heller draws a distinction between firearms commonly owned for lawful purposes and unusual arms adapted to unlawful purposes, as well as arms solely useful for military purposes. As applied to AWCA, the Heller test asks, is a modern rifle commonly owned by law-abiding citizens for a lawful purpose? For the AR-15 type rifle, the answer is yes. Yes, of course it is. The overwhelming majority of citizens who own and keep the popular AR-15 rifle and its many variants do so for lawful purposes, including self-defense at home. Under Heller, that is all that is needed. Using the easy-to-understand Heller test, it is obvious that the California assault weapon ban is unconstitutional. Under the Heller test, judicial review can end right here. Notice we're on page 13. He goes all the way to 94. This judge has laid out in plain English why an assault weapons ban in California that bans AR-15 style rifles is unconstitutional under existing law. He does go on to go through the Ninth Circuit's two-step level of scrutiny test, which isn't even important because Heller supersedes the Ninth Circuit's ruling. Heller is the supreme law of the land coming from the Supreme Court. It is the interpretation of the federal Constitution at its base. And the Supreme Court's view of the Constitution is the minimum bar that states must guarantee. States can guarantee more rights to their citizens, not less. Under Heller, this thing should be dead in the water. It should have never been drafted. Once Heller came out, it should have been shut down, but it was not because this is California. Anyway, at some point, maybe I will go through and break this thing into a series of videos and go through each section. It's really good stuff. For now, the best I can do is give you a link down in the description to the decision so you can read it yourself. And I encourage you to take a peek at it. It's great writing. It's very well done, and this decision will be cited at every level of appeal going forward because the judge has got some really good lines in there. He's got great analysis, and most importantly, he's got correct application of the law. And we all know this. The only people who don't happen to be in California politics. But that's the way it goes. Hope you guys enjoyed this. Make sure you share it if you found it useful and drop a comment down in the comment section. Let me know what you think about this. California, I'm rooting for you. I'm rooting for you guys. Until next time, peace. Peace.